The slides. I worry when I'm in control of the slides.
Good afternoon, everybody. Hello and welcome along. Alex and I are delighted to be recording this webinar session for you to look back on, watch back at any time that suits you, on conduct, culture and people, risk in construction. So this is being shared or will be shared by email and will be hosted on our website, and I'm sure Alex will be happy to share with anyone else who might be interested in the content. So what we're going to talk about today is exactly that. How do we, as HR and people managers, how do we translate our sort of normal management practices onto a construction culture? So what does it look like on sites, and what do we need to know? What do we need to be aware of? What do we need to be mindful of? So for those of you that don't know Alex or myself, welcome along. Really nice to meet you. Nice to have you here listening back to this recording. I'm Heidi. I'm Head of Learning and Development at Reality HR. We're a HR consultancy. We support businesses of all sizes in all sectors, and a growing number of construction companies and linked. So people in the architect space and planning. So lots and lots of contact with people in this kind of area. Alex, tell us a little bit about Herrington's, please.
Thank you for the introduction, Heidi. Yeah, so Herrington Carmichael, much like Reality, we work a lot in the construction sector and the kind of affiliated sectors within that. So, like you guys, we act for house builders, big kind of contract construction companies, but also architects, planners, surveyors, kind of going through the full remit, even in the waste management space and kind of the ancillary sectors of the construction kind of world. So we are a full service law firm, as you can see there, but I'm an employment lawyer by trade for my sins. So I really look at construction from the people side of things, much like you. So we operate across the sector. We have a working group across the whole firm, and all of us work in construction. But today, obviously, the focus is very much the kind of employment law elements of that, which we'll be running through together with the HR elements, as they also go hand in hand.
They do, absolutely. So we're going to look at, why is construction different to other industries? What are the similarities and what are the maybe differences if you're running a team or a HR support in the construction industry? What makes that different? What are the specific challenges? Why does site culture matter? So Alex is going to talk us through some of the legal considerations there. We're going to be thinking about having difficult conversations and handling conduct issues and conflict. Again, what are the specific challenges that might face those in the construction industry, and some more general advice here about early intervention, early resolution of conflict, what typically could go wrong in employee relations. So what are those things that we need to be mindful of as line managers and HR advisors in this space around employee relations? So how do we handle grievances? How do we handle disciplinaries? Where are the risks? So as always, when you get a session, when you come along to a session with Alex and I, we'll try and bring a bit about the law. What does the legislation say in each of these topics? But we also try and tell you what that means in the real world, because both of us have a very pragmatic outlook, and we understand that construction, any business, but construction in particular, is quite challenging to translate the law into a way that works for you and works for your employees, because pragmatism is really the watchword here, I think. So
Definitely.
why do we think construction might have different challenges then? Well, I guess this, for those of you watching back who work in the construction space, we won't be telling you anything new here at all. But some of the challenges come from having multiple sites. And each of those sites can be quite insular and can have its own independent culture. So it can feel very different. It's quite hard to keep a consistent culture going from the top of an organisation when you've got people out and about on various sites. And I guess there's lots of industries that have that same challenge. Thinking about retail and hospitality, each site can be its own micro kind of entity. But actually what we're hoping for, or I guess what, you know, at a group level, we're looking for making sure that we've got the consistency of culture, consistency of values, consistency of management approach across a variety of sites. Now, we have a very varied workforce across most construction businesses, because we might have a core of management that are our site managers, our regional managers. We might have our project planners. We'll have our on the ground, the trades, but actually we'll also have a massive amount of contractors, which is a challenge in itself, differentiating between our employees and our contractors. That can be or subcontractors. That's a challenge, and I'm sure we'll touch on that at some point through the session this morning or this afternoon. It is this afternoon for us anyway. Tight margins, project deadlines, high stakes, getting the job done mentality. Now, we know that there are always deadlines. Not to say there aren't in other industries as well, but actually it's a particularly fraught environment, I would suggest. And we have very, very tight turnarounds, and therefore we put our people sometimes under quite a lot of pressure. And that can mean that tempers can fray. We might well have challenges with the weather. I'm thinking about the 35 degrees that hit us last week that we weren't necessarily prepared for as a country. So those unexpected acts of God, if you will, can actually, you know, again, increase tensions on sites between employees, subbies, etc. So all of these things, I think, set construction as a challenge, you know, a particular challenge. I'm a very rewarding industry to work in, but particular challenges that face the people managers and the HR teams in the industry. Is there anything else you would pick up on, Alex? Anything else that you, in your experience, that sets construction apart?
I think high stakes is on the slide there, and I think that's a really interesting point to make, because a lot of people will say, "Oh, you know, we all work in high stakes industries. It doesn't really change from one set of business to another." But actually, in the construction sector, high stakes in and of itself takes on a couple of different meanings, in my view. So you've got the high stakes element in terms of, yeah, you could be working on a big deal, real huge financial value. You're driving a site to conclusion, and you know you've got to meet that deadline to sell whatever it is you've built, or you're working to a project, to a client standard, and you've got to go, and it feels very high stakes and intense. But there's also in the construction sector that element of the high stakes for personal people's involvement in this project. So, you know, I'm speaking from, you know, you could literally be working at height. You know, if you're building a skyscraper, that's pretty much as literally as can be high stakes. But also you've got a number of concerns in terms of health and safety, and fundamentally in the construction sector, one of your primary goals as an employer is going to be making sure that everyone who comes into work goes home safely at the end of the day. And I think that does often add a very different flavor, if you like, to employee relations issues that we come across in the sector that is incredibly unique. Well, nothing can be incredibly unique, but it is incredibly specific to the construction sector in a way that it isn't to others. So that's really all I would add there, in terms of why construction is different. But ultimately, employment law and best HR practice will be the same across the board, across every sector. It's really going to come down to how you apply it, and I think that application of employment law and HR best practice is really what varies, and what the construction sector kind of characteristics of it can make it different.
Yeah, I'd agree that the sector has some specific characteristics. We often have this male-dominated environment. We often have this transient workforce with lots of subcontractors. We have the pressure and deadlines and hierarchy, but also, as Alex has said there, those high stakes of the health and safety, the risk element to people's personal safety. So definitely challenges that are slightly different to other industries. I would guess that the common conduct issues are probably similar actually across some other industries as well. These are typical conduct issues that we're seeing on come out of sites, come out of construction companies, and you know, things we're being asked to advise on. every industry is having to take a long, hard look at itself at the moment on the banter versus bullying question. But I think some industries are harder hit by this. We've probably got, retail and hospitality, for example, factories, logistics, warehousing are all having the same challenge as we're having maybe in some of our construction sites around typically an environment full of banter, a very relaxed workforce, a very loose use of language, shall we say, very much about joking, teasing, nicknames. And actually, this is hitting headlines more and more as the legislation around harassment and sexual harassment is evolving. And societal expectations are evolving. We're seeing more and more that industries like construction are having to make some change to the traditional environment of banter. I'm sure you're seeing exactly the same, Alex, coming out of absolutely. And it isn't just construction, but I think that's maybe already on that journey. This construction industry is already on that journey, but it's still got some way to go potentially, and we're still seeing conduct issues in this space.
I think that's right, Heidi. I don't think anyone is immune from any of this stuff, but I think there are some cases and some sectors where it's more prevalent than others, and unfortunately construction kind of is in that block of, it's probably a little bit more prevalent still in construction than all of our HR teams would like.
Indeed, yeah, absolutely. So journey is ongoing. We've got substance misuse and aggression on there as well. And again, this is not something that's necessarily unique to construction, but probably more prevalent in construction than in many of the other industries we work across. And exactly the same point to make with these culture gaps, head office versus site, the them and us kind of environment, which we see in so many businesses, but particularly on sites, because you've got a head office group function, for example, in a very nice plush office somewhere, and then you've got people at the coal face out on sites doing the work. So there's often a them and us environment there, and that's echoed in the policy versus practice. It's very easy for us in our ivory towers or glass towers to write policies, but what happens in practice on sites out in the real world can be a very different scenario. So these are some of the things we're seeing, some of the challenges we're seeing coming through. And they really matter, because this difference between policy and practice, what's written down in the real world, is really important. I'll let you pick this one up, Alex.
Oh, I couldn't agree more, Heidi. It's culture's not just a nice to have anymore. It's a need to have, because it's a legal issue. There's no two ways about it now. We are firmly in the world where tribunals will care and look at in depth what a company's culture is like, because it paints a picture of the wider organization. And if you've got a discrimination claim, it is more credible that it's likely to have happened, or the claim itself is more credible if the background culture to the organization is seen to be one that perpetuates that kind of environment. So workplace culture, management behavior, previous kind of complaints, history of this sort of behavior, whether that be discrimination, harassment, or just inconsistent application of policy, whatever it is, if you've got historic issues in that's going to count against you in an employment tribunal potentially. Thinking about kind of policies and practice, the tribunal is not just going to care whether you've got a policy anymore. It's not enough just to have a policy sat there on your intranet or gathering dust in a drawer. If you aren't putting it into practice, the tribunals care about that. They look at that. They're going to look at what is actually happening on the ground. And we're moving beyond just having things written down. And that does create an interesting issue in sectors like construction, where sometimes your workforce, actually most of your workforce, doesn't have access to a computer anyway. So how are they getting the policy? How are they reading the policy? How are you ensuring that they're getting the training they need on diversity and inclusion, or even any other kind of mandatory training that you're having to deliver? It doesn't just create a sort of expectation of, oh, we've got it in place so it's enough. the tribunal is going to look at how you're making sure people on the ground are actually understanding what the policies are and then following what the policies say. I've got on the slide there, tribunals look at reasonable steps. Now, obviously in the base, the fundamental basis of a lot of claims is how reasonable the employer has acted. But specifically, reasonable steps here is referring to the reasonable steps defense. So that's where you've got a type of claim such as discrimination, and the employer is saying, we've done everything we can. Look at our workplace culture, look at our top-down messaging, look at our, kind of risk assessments and policies and everything, and our training. So actually, we're fairly confident that whatever this individual employee has done or is being accused of, we're not responsible for. It's a difficult defense to run. It's not often successful because it's difficult to say you've taken every reasonable step possible to prevent the kind of conduct that's being complained of, but it's certainly something that you may want to rely on in certain cases, and you can successfully apply if you have done everything. So looking at that whole picture as a whole, it's not just the right thing to do anymore. All of these things are not just nice to haves, they're also need to haves, because if you do want to put yourself in the best position possible to dispute or defend an employment tribunal claim, then you want all of these things in place and in practice, so you can say, actually, that employee is nothing to do with us and they're on their own. I've talked briefly about this and I won't dwell on it because most people, I think, watching this webinar will already know the consequences of getting this wrong are severe, but they are slightly different in the construction in the construction sector. They go beyond just the worry of having an employment tribunal claim or even having compensation. A lot of our clients in the sector are very, very concerned about reputational damage, particularly when it comes to findings that might arise from a discrimination-based claim, because often pitching and tendering processes will require a company to report on whether they have any findings of discrimination against them in the employment tribunal. Now, that reporting that and losing a pitch on that basis is worth more to that client than potentially the entire value of that claim. So there are real kind of commercial drivers, if you like, for dealing with employment tribunal claims in a certain way, and not risking having a finding of discrimination made against you. Now, best case scenario, you've done everything right on that left-hand column, and you're not in the world of the right-hand column. But if you are, that's a real concern, and that's something that's quite unique to the sector. Attrition and staff retention, obviously that applies in a lot of sectors more broadly, in fact, probably all of them, given the state of the economy at the moment. But
we find that this is a small world. Construction is a small world, and reputations, individuals' reputations precede them, but also employers' reputations precede them, don't they, Alex?
And I was going to say exactly that. And there are certain sub elements of the sector that are really, really tricky to recruit for. Like, for example, forklift truck drivers are, like gold dust. So you don't want to create a scenario where someone doesn't want to come to work for you because you've got a reputation as having a kind of toxic culture. And then the final point I've put on the slide there, which does have a different spin on it, is that not only does an employment tribunal claim potentially mean going to the employment tribunal, if certain elements arise as part of that claim, for example, perhaps you have a whistleblower who's raised health and safety allegations, then you've got the health and safety regulator knocking on your door, which obviously is incredibly damaging potentially to a construction client. So those are the things that sort of really underpin why culture has become a legal issue. It's not just a nice thing to have anymore. As I've said, it is now absolutely essential.
Yeah, and I think this is where we're seeing the biggest challenge for construction companies, that the whole industry is, like I said earlier, is already moving on this journey of improving culture, taking away some of those elements of toxicity or that extreme banter, all of those things. We're on that journey, but I think as most HR professionals listening in will think there's always more to do. And as Alex has so clearly shown us there, It's things that we have to keep doing. We can't rest on our laurels and say we're done, tick, we've finished this bit. Actually, there is always more to do. And I think that one of the areas that we can make sure we're really on top of is with our managers handling conduct issues effectively. We know that conduct issues on sites have historically been quite prevalent, but because of the risk of health and safety, because of the traditions of the industry, actually it's even more important that we address them early. We can't let anything slip. We can't turn a blind eye to anything. Now, some of you will be working with site managers who would much rather turn a blind eye to certain things because it's easier. They don't have time. They don't want to disrupt their time frames. They don't want to lose an employee partway through a job. They're worried about replacing an individual, of course. And we understand all those practical challenges that our site managers are facing. But actually, this is such a crucial area for setting the right tone and setting the right culture that we need our site managers to be brought into this early intervention before something has to escalate. We're not sitting here, either of us sitting here and saying go and sack everyone for every conduct issue or every so our interventions don't need to be that extreme if we take some early action. And that is where I think it's about managers, our site managers, those on sites live out there, need to call out behaviour in real time. They need to have those difficult conversations immediately. They need to be calling out behaviour and not sweeping it under the carpet. Now, calling it out publicly or privately with private word with the individual afterwards is going to prevent a lot of escalation. Not always, but at least you've started the ball rolling. You've got your foundations in place. Should that individual repeat their conduct issue, you've already done that early informal approach and you're ready now to go into something more serious if you need to. But the advice we always give to managers, any sort of people managers in any sort of industry, is actually if you call some behaviour out, if you say to the individual that isn't up to standard, that isn't the way we behave here, please don't use that sort of language again, or please make sure you follow the SOP in this, or you're following the risk assessment. Whatever it is, if you call it out early, for the majority of cases that fixes the problem. The problem comes where we don't call it out. The person knows they've got away with it. They do it again the next day and again the next day, and then their colleagues start copying their poor performance or poor conduct, and then before we know it, we've got a whole team of people doing the wrong thing, whereas we could have prevented that if we'd literally just had a quiet word with that individual in the first place. And so we kick ourselves with hindsight, but actually that's the key, is that early, call it out there and then. Make a note if you need to, depends how good your memory is, but do that very first informal step. And thinking about why we need to do it early is really important. So getting that through to your site managers. Those on the front line need to be the ones that have got the confidence and the knowledge to call it out. And maybe that means they're changing things. That historic tolerance is a real driver in this area. It's a real issue in this area that it's always been allowed. And how do we change that? Well, none of us wants to be the first one that starts sounding like we're policing fun. None of us wants to be the first one who's saying no, you can't do that. Yeah, you might have done it for years, but it's no longer acceptable. But someone has to be the driver of that change, and when we've got one person spearheading that change, all our other managers need to fall in line and do the same thing. So I'm sure I'm preaching to the choir for those of you watching this back, but I guess what we're trying to say is if you're not getting through to your frontline managers, if they're not doing this, then give us a shout, because we can help. We can help batter that message into them for you in the politest possible way. I'm not condoning any sort of violence there. So let's have a look at a bit of a case study then. This is a sort of an example of something that might have happened. So we're a groundworks and structural framing project. We've got a team of 15, predominantly male workforce, but Sarah's joined as a site engineer. Now, the culture on this particular site is regular joking, banter, often with sexual undertones, comments about women, comments about Sarah and her competence in particular. Sarah hears colleagues say things like she was only hired to tick a diversity box. So she starts to feel isolated. She's reluctant to contribute to conversations. She gets away as early as she can. She leaves on time at the end of the day. She takes her lunch away from the team. So she's withdrawing from the team. I'm sure this example or case study resonates for a lot of you listening. We're then in the scenario where Sarah puts in a complaint. She feels that there's a hostile, unprofessional working environment. She talks to the site manager, and they say, that's just how the lads are. That's what happens on building sites. Put up with it. If you don't like it, don't work on a site. Wow. We've all heard that as well, haven't we, Alex? We've heard that exact response.
Oh yeah, it is the kind of adult equivalent of boys will be boys, isn't it? It's
Yes.
we've all heard it, sadly.
Yeah. Yeah.
And we're all still having to deal with it.
Yeah.
Heidi, I'm conscious that usually when we go through a case study, we'd probably do interaction with the audience. So instead of that, shall I actually ask you a couple of questions in terms of the HR perspective, and then do you want to talk me through the legal perspective? Just because otherwise, I think it feels a bit like we're teaching everyone a lesson, like we're back at school. What do you think in this situation? Like, what should the site manager have done? Where's he gone wrong?
Should have taken it seriously, should have listened to the concerns, maybe with some empathy, recognition, or understanding that it probably took some courage for Sarah to actually come and speak to him. And he should have thanked her for speaking up, really, and listened empathetically, honestly, curiously. Well, tell me more. And why does it make you feel that way? How do you feel about that? What specifically has happened? And how would you like it resolved? So should have been open to hearing it and curious to find out how Sarah would like to see this resolved. And depending on Sarah's response there, the site manager could well have just had a quiet word with the lads and asked them to tone it down, reminded them of the dignity at work policy, for example. Or if Sarah felt it was more extreme than that, or the site manager heard any particular phrases that really struck an alarm bell, then maybe they should have done a formal investigation. Pretty much every company has a dignity at work policy that says, we have a zero tolerance approach to any form of harassment. So the site manager's got that responsibility to make sure they're considering what's in the policy. And Alex, I'll just say there then, was this banter or was it harassment? What do you think from a legal perspective?
It's a good question, because we do get a lot of that. Oh, it's just banter. It's not harassment. And I think, and my favorite, which is they didn't mean it that way. It's not, it's not intended to be, harassment. And
it was just a joke.
It was just a joke. Yeah. And I think we've all heard that before. And, unfortunately, I'm going to probably end up saying this until I'm blue in the face, but harassment, it doesn't matter whatever the comment was or whatever the joke or whatever the action was, it does not matter. The Employment Tribunal does not care how it was intended. They only care about how Sarah received that comment and whether that made her feel like she was in an environment where she was being subjected to kind of unwanted behavior that's done exactly what we've said what she said in her complaint. It has created an intimidating, a hostile and unprofessional working environment, and I feel humiliated or I feel undermined as a result. She has ticked that box. So legally speaking, this is harassment. This isn't banter. It's gone so far beyond that. And there are legal risks when that comes into play, because here it's quite clear that Sarah's going to bring us, Sarah's got grounds potentially to bring a sex discrimination claim, including harassment on the grounds of sex, which is which is kind of harassment on the basis that she's a woman. But also she's potentially got a claim here for sexual harassment because of the jokes with a sexual undertone, which is a separate head of claim and creates another set of legal risks as well. Many of our viewers will be familiar with the Worker Protection Act. Companies are under the greatest scrutiny that they've ever been in terms of preventing sexual harassment, and here we are walking right into not only a sex discrimination claim, but also a claim for sexual harassment, which obviously attracts that new 25% uplift on any awards. So there's a really strong legal risk here out of the situation that we've got here. And I think it's important to point out that the tribunal is just not going to find the management response of that's just how it is to be acceptable. So, I agree with you, Heidi, this could well be something that's resolved informally. But what I would want to see even in that scenario is a written account, an update to your sexual harassment risk assessment, showing that this complaint was made, how you dealt with it. Basically, you're going, even if you're doing informal conversations, you're going to want a formal document of some kind which sets out what was done in response, even if it's not, we gave written warnings and we did disciplinary proceedings against the individuals who made the comments. So it's and obviously that depends on how far it needs to go. If you are going into the world of disciplinaries, then again I'd be expecting strong documentation and then thought process at the very top about how you're addressing the problems, and because if it's happened in one site, is it happening in others? So I think from both a kind of discrimination based kind of risk base and also that critical now Worker Protection Act base, you're going to need a lot of documentation to show that awarding a 25% uplift if this happens again wouldn't be justified.
Yeah, some great comments there, Alex, about whatever action you take, write it down.
Absolutely.
Keep a record at the time, because you're not going to remember in a month or 2 months or 6 months if a complaint comes in. Resolve it in the way that feels right for Sarah's requirement, for whether that's an informal resolution or moving into the formal grievance procedure, investigations, disciplinaries, but keep a record either way. And I love your point there, Alex, about looking wider. If it's happening on this site, is it still happening on other sites as well?
Yeah.
And therefore our risk assessment across the organisation hasn't captured everything. Maybe our training hasn't been effective, because presumably all these chaps on site have been through some compulsory EDI or bullying and harassment training. Obviously hasn't worked. What can we do differently? How can we go back and readdress this issue site-wide, company-wide? So lots and lots to think about, and definitely some training for this manager.
Yeah.
To show
absolutely.
them how unacceptable that kind of brushing it off response is. They obviously aren't aware, maybe they are aware and don't care, but they may be not aware of the risks of doing that and how they exacerbate the problem. So not only is there a problem that we've got these workers on site saying comments like this, but we've got a real problem that our management team aren't addressing it. And if that manager was so quick to say, well, that's just how the lads are, they obviously knew that was happening.
Yeah.
So they knew it was happening. They allowed it to happen. They then brushed off a concern that was raised and escalated the whole problem. So all the people involved here it really needs looking at, and we can't just let this go and go, well, construction, a tribunal is not going to go, oh, it's a construction site. Yeah, the lads are always like that.
No, well, not least because a lot of the judges, with the greatest respect in the world to them, will have never set foot on a construction site.
Absolutely. Yeah, absolutely right. So I've just mentioned a few of these things as managers. Then the managers are your first line of defence. They are your eyes and ears on sites, and so you need your managers, your site managers, those regional managers, those that are out and about. You need them firstly setting a good example with their own behaviour, that they're not part of the toxic culture, but actually be that they're proactively looking out for instances where banter might be crossing into harassment, where banter might be going too far, where joking isn't joking anymore. If this manager in our case study there had been proactively looking out for this, they would have stopped all that kind of conversation before it came to Sarah making a complaint. And that's what we're looking for. That's part of those reasonable steps, a big part of your reasonable steps defence is going to be actually, do our managers actively look and actively prevent it from escalating and actively stop this stuff happening? Speaking up early, nipping issues in the bud, reminding individuals of policies and behavioural standards required of them. So don't just write, we have a zero tolerance approach in your policy, actually live it, breathe it, and enforce it. Be approachable. And how I said, it probably took Sarah some fair amount of courage to speak up. Our managers need to be approachable. They need to be showing our staff that they will take any concerns seriously, that they do want to hear and resolve and help resolve concerns. And that's not just about bullying and harassment. That's, of course, any personal concerns people may be having, any mental health challenges, any work-related concerns. We want our managers to be approachable and our staff to know that they can speak up, that it's a psychologically safe environment, that they can speak up and share concerns, and that staff that the managers are going to support them through a resolution. And more broadly, our managers are responsible for ensuring all staff are aware of company policies, the values, and the cultural expectations. So there's a lot to consider in that one small scenario that actually we've probably all come across. And a lot of responsibility on our frontline managers. I think more responsibility at this moment in time than our frontline managers have ever had.
Yeah.
And that is going to need a real mindset shift and a real training program for most frontline managers to be up to speed with the new requirements of them that are being placed on them.
I couldn't agree more, Heidi. And I think as well, what we have to say, I think would be remiss not to say, is that employees have access to the most amount of information that they've ever had before in the form of AI, because it is so much easier now for an employee to go, this has happened to me at work, what do I do? And then a manager who perhaps before in the past would have been pulled aside to a room with a really upset employee saying, I'm really upset about XYZ, is now getting a 25-page grievance or a 25-page letter setting out all of this person's complaints in granular detail, and it's preparing them to be prepared for that. And to be, what are you supposed to do when you get, you suddenly maybe would have had a conversation with a person before, but now you're having a conversation with AI about it, and AI doesn't stop. So we're in a whole new world for managers. They are really on the front line more than ever, and things escalate more quickly, I think, now than they traditionally have.
Yeah. I'd agree. I think we're seeing a massive increase in the volume of formal grievances raised and the complexity of those grievances. It's not that the actual concern that people are raising is any more complex. It's the fact that AI is writing them a 17-page grievance letter, whereas before they would have put a 1-page or a 2-sentence complaint into their boss. So I would agree, Alex, that employee relations is challenging and growing as an area in every industry. And we know that on sites it's even harder for our frontline managers to deal with, because of the operational disruption of taking people away from their jobs for meetings. We know we've got these pressured timelines happening. Taking people away from their task means the next bit, the next trade can't get on with their bit, and then the next one can't get on with their bit. So we fully understand that. Unfortunately, this isn't a nice to have. This isn't I'll have that meeting in 2 weeks' time when we finish this phase 1. You cannot afford to allow operational challenges to delay any of these kind of meetings. If you've got an ER issue, an employee relations issue, whether that be performance, conduct, a concern, a grievance raised, a potential disciplinary, you cannot delay it because of operational challenges. We know that space to have a meeting with someone can be challenging on site. There may not be a bunch of private meeting rooms that you can book and have a confidential conversation. So how are you going to work around that? Were you going to meet people off site? Are you going to book a meeting space somewhere else? Are you close to your head office and you can go and use a meeting room there? I've seen a number of occasions where managers say, well, I couldn't have the meeting because there's literally only the site and there's no private space at all. So I couldn't say it in front of other people, so I didn't bother saying it. That isn't going to wash in court either. A tribunal is not going to accept that as an excuse for not having had those early conversations, for not having investigated a grievance or a disciplinary issue fully. So how do you make that work? Maybe you need to liaise with other sites, within the group. Maybe you need to get people off to head office. Maybe you need to just rent an office in a WeWork space. You need to work that out. You can't use it as a reason not to make this happen. And frontline managers have these skills, capability, confidence gaps, and that means the support from the HR teams or the central team, the support from the more senior management or the HR teams is going to be absolutely crucial to empower our managers, the frontline managers, to do this, but also enable them to do it and provide them with guidance in how to do it and how to do it correctly. So if you haven't got that sort of level of HR knowledge in amongst the organisation, you must get that advice from someone early on. Alex, how many times have you come across where a manager started a process, they've missed some of the early stages, they've not done a decent enough investigation, they've jumped straight into warnings, we get brought in too late. As professionals, either you come to us or you come to Alex and her team, and it's once you've started down the wrong road, once the managers have started in the wrong direction, it's nigh on impossible for us to unpick it and start again. So take that advice early, and if you haven't got your in-house HR, get support from someone external like Alex or myself.
Yeah, I could not agree more. I heard recently explained as get it when it's a snowball before it's an avalanche.
Mm-hmm.
And and I'm sure you're the same, Heidi. I'm brought in when we're in full-blown avalanche. And I could have been brought in when it was a snowball and it would have been a really discrete issue to resolve. And so I couldn't agree more. It's kind of all of that early intervention piece that you've been talking about a lot through this session, which is it's not just for managers, right? It's early intervention in terms of getting the advice you need to protect yourself down the road, particularly with cases like our case study where we're looking at discrimination or harassment-based claims. These are the highest risk space for employment tribunal claims for the sector. So getting advice early is always going to be beneficial. I cannot think of a scenario where it wouldn't be.
No, absolutely. Even if the advice is no, just watch and wait and see, which is very rarely the advice, I have to say. But even if it were the advice, it's keeping that watching eye on it. It's making sure someone knows early on. The last point's an interesting one here about managing multiple, we've written employees, but actually managing multiple people in different buckets or different categories. We've got employees on sites, we might have agency workers, we've got contractors, we've got subcontractors. And each of those will need a slightly different approach to a conduct issue or a grievance raised or a potential discrimination harassment claim. And so it's essential that your line managers know which category of worker each person's in. You need to know who's an employee, who's a subby, who's through an agency, which agency are they through, because there are different processes. And again, that's where you're going to need that HR or professional advice from ourselves or from Alex and the team to know how to deal with each different scenario based on each category of worker. So a big challenge, an absolute challenge. And what often goes wrong? Let's see what some of the legal pitfalls are. What are the mistakes, Alex, that people make?
A lot of them are actually sort of ER based, to be honest. They're not legal mistakes as such. It's just things that you've got to think, whatever you do, what is a judge going to think about this if I see it? You see it I see it probably because of my algorithms, but on LinkedIn I get targeted with memes like dance like nobody's watching, but email like is going to be read out in the employment tribunal. And it's true, a lot of these common mistakes are actually really, they seem small at the beginning, but like cumulatively, and when you look at it and you've suddenly got a judge going, why wouldn't you have done this? I just don't understand why you wouldn't have spent the time. And you're suddenly in the witness box under fire. It takes on a whole different color. So for example, informal handling of serious issues. Now we see this a lot in the sector in the context of that, it's just the lads.
Yeah.
And so we informally deal with something, and very often it's the woman doesn't want to kick up a fuss, so doesn't want to make a scene, doesn't want to be the person that's causing a problem. Um, and so things get resolved informally at first when they shouldn't be. They should go straight into a kind of formal process. They should be doing disciplinaries. They should be, taking much more proactive action. And they don't. So then the tribunal's like, well, this was foreseeable when you did this informally, and then 2 months later, another grievance, a grievance got put through. Poor investigations and evidence gathering, that's when we see a lot. So it's that's not unique to construction, and I should say none of these are unique to construction by any stretch. But there are particular nuances in a construction environment that do make evidence gathering harder. A lot of things aren't written down. And poor investigations, the thing I typically see is no kind of documentation at any stage in the investigation. So my most favorite thing I see when I get a host of documentation from a client about a process is an investigation report that the investigation manager has put together and basically just says, these are my sort of rough thoughts. These are the thought
Mm.
processes. This is why I've done this. This is why I've done that. This is why I
Mm.
haven't done something.
Yeah.
Because the problem is they don't remember that down the line. And we've got to remember that in the employment tribunal context at the moment, it could take 2, 3, 4 years maybe to get to the employment tribunal. And some investigators are not, some will, but most won't remember what they did 4.5 years ago.
Mhm. Yeah.
So having that documentation at every stage of your investigation and really making the effort to find evidence and then explaining why you couldn't is gonna pay dividends later down the line. Like kind of ignoring behaviors, I think we've sort of covered already, so I won't dwell on
Yeah.
that because we'd
Yeah.
we'd be repeating stuff you and I have already spoken about. And likewise, that's just site
Yeah.
culture, kind of over relying on that. My other least favorite thing as a lawyer is inconsistent treatment. We love consistency. Lawyers famously love consistency. So if you're going to do one thing, that's fine, but do it for everyone. Don't be inconsistent in how you apply a process. Don't be inconsistent in how you kind of run investigations, for example, and also don't be inconsistent in outcomes. So don't terminate someone's employment for gross misconduct, but give someone else for the exact same thing a written warning. You just want
Yeah.
consistency across the board. And then predetermined outcomes. This is a huge problem. Again, not unique to construction by any stretch,
Mm.
but making the facts suit the outcome that you wanted from the beginning, rather than looking at them and investigating and coming to a conclusion based on what they're saying. Don't do this if for no other reason than it's blooming obvious. When you look at a outcome that doesn't match the fact profile whatsoever, there's only one conclusion to draw from that, which is they'd already decided what they wanted to say before they said it, and whatever was presented as part of that investigation wasn't going to change their minds. It's just obvious. So, go into those processes with an open mind and look at what the evidence is actually saying and make conclusions on that basis. The kind of four key kind of legal elements that I would say, and they're not even legal, but the things that the tribunal will be caring about in different kind of frameworks, depending on what the legal claim is kind of how reasonable the behavior has been, how reasonable was a decision. Was it fair? Not just in the unfair dismissal sense, but also in the sense of did this make sense for an employer to do it in the circumstances based on their
Mm.
size? Were there
Mm.
alternatives that they could have considered, and would that have been fair for them to do it? Have the decision makers been objective? Have they kind of looked at the facts in a way that makes it clear that they are coming to conclusions based on the facts rather than an outcome they've already decided? And as I mentioned already, being consistent. So being consistent in your approach throughout process and also consistent in the outcomes and how they're applied. So those are my kind of top tips from my experience, Heidi, I have to say. But they are not unique to construction, but some of them do have a nuance for the sector because of the difficulties that you've spoken about in terms of ER kind of operations.
Yeah, absolutely. I think, as we've said a few times here, we are expecting a lot of our frontline managers, of our site
Mm,
managers, of our project managers. We are expecting a lot of them. And so if they haven't been through a robust training program, if they haven't got the experience in a kind of maybe a supportive environment, then you really need to be thinking about what support's available to them, and what
mm,
training might they need. Our frontline managers are the ones who are going to help change culture. They are the ones that are going to be moving from this reactive, passive, it's just how sites are, it's just how the lads are, actually moving us into a proactive, positive culture that is inclusive and welcoming of all. Um, So, what actually works? Well, setting visible leadership behaviours in setting the tone and the culture, and that's from your site managers, that's from your area managers that are visiting, that's from your regional managers, that's from your project directors, that's from everybody. How visible are the senior teams on sites? Do they ever visit the sites? Would your staff recognise the MD or any of the other sort of operational directors? Would our staff know who they were? And when they come on sites, are they displaying the right behaviours that we're looking to encourage? Is there some sort of accountability at site level for all of getting these things right? So yes, every site manager or every site's going to have accountability for achieving the work on time, and no health and safety risks, or reduce number of near misses, or whatever your KPIs are in that space. But actually, could there be some sort of KPI or target or challenge around people issues? Are we having one-to-ones with our staff? Are we creating an open environment? Do we do staff surveys to find out if people are happy with the culture, and do they think their managers are approachable? Is there some way we can make people and getting our people processes right an accountability or a KPI for each site? Now, there will clearly be some challenges in some of those ideas, and there'll clearly be some ways that they need to be slightly different from how these things might run in a more office-based environment, or a more white-collar environment. I hate that phrase, but everyone knows what we mean by it. But there's no reason we can't make some of them work on a site basis. And do we have the right behavioural standards, not just the right policies? So I mentioned training earlier. Everyone will have a suite, I'm sure, of compulsory training around health and safety, around site procedures, around modern slavery, hopefully bullying and harassment, dignity at work's in that suite that you're providing. But if you are getting repeated issues in any of those areas, your training is obviously not working in its format. So look at the format you're using. Does it need to be the site manager doing a toolbox talk rather than expecting people to log in on their phones and do an e-learning tick box activity? What are you doing, and what could you do differently if it isn't working? How do we make training really stick? And that will need to be tailored to the individuals, to the type of site, to the type of topic. But again, there's loads of L&D out there. There's loads of L&D options that are tailored to construction, tailored to hands-on environments. Think about what we could be doing differently if you're not feeling it's working. So doing that training, refreshing it, using a different format, maybe each year when you do your rollout, your repeats of the same training every year. Don't use exactly the same format and function. Do something different, change it up, switch it up. And don't just rely on that compliance training once a year. Make sure you've got inductions right for your new starters. Make sure you've got the right bits of this stuff in your contractor contracts, so your subbies are knowing what their expectations are. And when you're promoting people internally, when you're bringing people on into supervisor, team leader, manager roles, make sure you're giving them the skills, the knowledge and the confidence to actually be a frontline manager. So there's a lot of things that we can be doing. We can be rewarding the right behaviours, we can be providing the right sorts of training and then making sure we're setting that culture and tone from the top. Okay, we're almost there. So those of you that are still with us, thank you for your attention. We are going to touch on the Employment Rights Act, because what training this year would be complete without mentioning the Employment Rights Act. Alex, I'll let you just talk us through where you see is most relevant to our construction companies.
Yeah, I mean, obviously we could do, and we will, in fact, do a whole session on the Employment Rights Act, and Heidi and I have been doing them throughout the year. We've got another one upcoming, which the link for will be available when we have sent you these slides. So please do sign up. We're doing an update for the Employment Rights Act, the next phase, upcoming in October. But just thinking about it from a purely kind of, where are the key areas that I can see the Employment Rights Act 2025 affecting construction? It's fundamentally not just about employee rights anymore. We're going to have, as part of this wider kind of initiative, much greater scrutiny on how managers manage conduct, culture, and workforce practices. Not least, as you can see from the slide, from the Fair Work Agency, which is going to be given increasing powers as time goes on to looking into kind of breaches of all kinds. They are throwing everything at them eventually, and they are going to become this sort of, well, the aim, I think, is for them to become a regulator which rivals something like the health and safety regulator, and has that executive, exactly, and has that kind of level of enforcement ability. So I think it's one to watch and one to be aware of. Obviously, we've got the stronger sexual harassment prevention duties coming in October, and that's what Heidi and I will be focusing on a lot in our session. Then there's also going to be less margin for error, more than ever, because we've got unfair dismissal rights becoming applicable from 6 months or 5 months and 3 weeks. And so managers are going to have to be getting this stuff right much quicker. And on a construction site, that's not always easy, because the issues don't necessarily become apparent quickly. So it's just going to be about making sure we're looking at these things as soon as we can and addressing them much before the 6-month mark. That I think a lot of managers in every sector, to be clear, have always felt like they've got that safety blanket of 2 years. That is gone, guys. Like, as of now, that's gone. Anyone you've hired from now is going to have 2 years service or the equivalent of it by January. So
probation is going to be so much more important, and
exactly,
typically we don't see in many areas, in many companies, we don't see robust, good probation reviews. In construction, it just doesn't seem to be part of the culture. It's embedded in certain industries. My experience is it's not embedded yet across most construction sites. So these probation reviews are going to be essential to getting that, to knowing within 6 months if we got the right person here or not. Do we want to keep them or not? And can we evidence why we've made that decision?
Yeah, exactly. And then scrutiny for flexible worker models is going to be on the up and up and up. Labour have signposted this several times. The age of the 0-hour contract is possibly coming to an end. I don't know how true that is, but that's the direction of travel. They are really scrutinizing how we're working and whether we're protecting the people we're working with. And I think the construction sector is one of those sectors where this is going to hit quite hard. And actually, I haven't put on this slide, but as well, something to be aware of for all employers, but particularly in construction, is the rights of trade union access are being increased so massively as a result of the Employment Rights Act. And construction is going to be one of those sectors where unions are looking and going to start knocking at doors where they weren't previously. And I think it's another layer of scrutiny in terms of what you're doing, and from another kind of angle. So that's just something to be aware of. I could run a whole session on trade union access and all the rights and all of the kind of legislation that's changing as a result of the Employment Rights Act in respect of unions. But just as a watchword, just be mindful of it. And if you've got any questions, please email Heidi and I afterwards, and we can either run a session on it maybe one day, or I'll certainly answer the questions that you have in terms of that space. But
wow,
that's the end. You've made it. Well done.
You've made it. Yeah, absolutely. I was just looking at the time. We've been a full old hour, I think, there, Alex. So hopefully we've still got people here with us right till the end. And I guess the big takeaways, the summaries then, are that culture drives risk. Culture is not just what's written on paper, it's what actually happens on sites. First one. Second is your early intervention, getting your line managers to intervene early, to resolve conflict early, to pick up concerns and issues early. Absolutely crucial to help you avoid any repercussions. Consistency is critical. So both on picking up people for the same types of behaviours rather than letting some people get away with it and others not, but also consistency of outcome. If we're going to do a disciplinary process, do we give similar level warnings for similar offences? So that consistency is absolutely key. And having things written down will help protect you in 3 or 4 years' time when your tribunal comes to the judge. You need it written down because you will not remember it. There we go. As Alex said, we'd be delighted to take any questions. When we share these slides, we'll have both of our sets of contact details. There we go. Email addresses, phone numbers. Get in touch with either Alex or myself if we've got any questions. Anything further you'd like to hear us talk about, as Alex suggested, maybe there's a trade union webinar in the offing, or if there's anything else you'd like us to cover, please do let us know. We hope that's been useful. Thank you all for listening.
Thank you.